And I will call the next case. Excuse me, People of the State of Michigan versus Dante Eric Wells. This is a mini oral argument on the application, each side having 15 minutes of argument. Mr. Burton, both sides have 2 minutes fire-free zone. If you would like to reserve any time for rebuttal, we just ask that you keep track of it.
Yes, Your Honor.
Proceed when you are ready.
Yes, Your Honor. Good morning. May it please the court. My name is Garrett Burton. I'm from the State Appellate Defender. I represent Mr. Wells. This court in Beck held that a trial judge violates due process when they sentence an individual based on acquitted conduct. When a trial court talks about that acquitted conduct, we can presume that they've considered it. And a trial court cannot use magic words to skirt Beck's holding. That's what happened here. The trial court said that Mr. Wells had an intent to distribute. It then sentenced him at the top of his guidelines, 4 times higher than the MDOC's recommendation. And in doing so, it made cursory reference to permissible sentencing considerations. It tried to insulate itself from Beck with a disclaimer, but that didn't work. And for that reason, Your Honors, Mr. Wells is entitled to resentencing. So with that, I'll waive my free fire period. And I'll start first by talking about the first question that this court asked, which is whether Mr. Wells was acquitted of anything. And he was. So Mr. Wells has a due process right to have the prosecutor prove every element of a criminal charge beyond a reasonable doubt. The failure to overcome that burden is an acquittal. The United States Supreme Court has said time and time again that when a jury is given the option to choose between a principal charge and a lesser included charge, and they opt for that lesser included, an individual is acquitted of the principal. And that's what happened here. Mr. Wells was charged with possession with intent to distribute, and a lesser included charge of simple possession, and the jury chose simple possession, thereby acquitting him of that intent to distribute. I don't think the prosecutor really takes issue with what I've said so far. I think the thrust of the prosecutor's argument is that the import of an acquittal is different under the due process clause than it is under the double jeopardy clause. The prosecutor cites no case law for that distinction, in large part because no distinction exists. There's no reason to treat an acquittal differently from one amendment to another. Don't take my word for it. That's what the Court of Appeals said in Brown. So there, the majority, in trying to decide what constituted acquitted conduct, they recognize that Beck is a due process case. But double jeopardy is nevertheless useful. And so for that reason, we can look to double jeopardy to guide us in determining what constitutes acquitted conduct. And the Court of Appeals cited Nutt, which is this court's double jeopardy jurisprudence case. In Nutt, this court laid out the test for determining whether double jeopardy attaches. And it's clear that under Nutt, the due process clause and the double jeopardy clause are bound up. The first step in a double jeopardy analysis is to determine whether or not someone was acquitted under due process. The other thing I'll say is that the Beck court, in defining what acquitted conduct is, it dropped a footnote. And it said, acquitted conduct is not our term. Acquitted conduct is a term that we're borrowing from the United States Supreme Court. And then it cited Watts, which is a double jeopardy case. What that means is that the Beck court did not make any distinction between what acquitted conduct was in defining it, but rather considering it differently under the due process clause and under the double jeopardy clause is how the Beck court thought about acquitted conduct. So unless there's any questions on the acquittal piece, I'll turn to the Beck violation piece. So, Your Honors, you asked me whether or not the trial court violated Beck, and they did. So, like I said, when a trial court's talking about acquitted conduct, they're considering it. And so Judge Miedema, when she sentenced Mr. Wells, she said, at trial, we heard all about these baggies and these drug ledgers and this cash, and the police officers who testified said that's all drug profile evidence, evidence of drug dealing, and I think that shows you have an intent to distribute. That was the one thing that Mr. Wells was acquitted of. Then, like I said, the trial court sentenced Mr. Wells at the very top of his guidelines, It made cursory reference to permissible sentencing considerations. It said only briefly that he was older and that he had a criminal history. And that's all that happened. And that, in totality, taken together, is evidence that the trial court violated Beck. Now, I recognize that the trial court did say you were sentenced, or excuse me, the jury convicted you of possession of methamphetamine, and that's what you'll be sentenced on. That is best read as the trial court recognizing that simple possession has different statutory minimum and maximum in guidelines than possession with intent to distribute. But even if you think that the trial court was trying to take back what it just said and disclaim any reliance on acquitted conduct, it wasn't successful in doing that. That's because the trial court spent all of its time talking about Mr. Wells' intent to distribute. And then it tried to take it back, but it can't unring the bell. And that's what the Court of Appeals, it's the same conclusion that the Court of Appeals came to in Brown and in Kilgore, that you can't say someone has done something that they've been acquitted of and then try to take it back.
Counselor, let me offer maybe even a harder case. Imagine
Sure.
there's a case where there's a possession with deliver charge, but it's based solely on the quantity of the narcotics. And so there's, where a statute, where a small few grams of something is the same guidelines or the same offense as a tremendous quantity. And so the prosecutor charges possession with intent to deliver, the defendant's acquitted of that but convicted of possession. And so I'm trying to, for guidance in thinking about how courts would deal with this going forward. Where is the line of what is permissible and isn't? So could the quantity, that larger quantity, be in the pre-sentence investigation report?
Well, Stokes would say that it can be in the pre-investigation report as long as the judge doesn't rely on it, that quantity.
Okay. And so I think the prosecutor would argue that, that facts about the other offense are permissible. And so in that instance, could the court say on the record at sentencing, this is the amount of the narcotic that you were convicted of possessing? Would that be permissible?
Yes, Your Honor, I think it would. And let me explain why. So Brown, the Court of Appeals case that determines or that thinks about what constitutes acquitted conduct, it announced this test, the rational jury test, that says we're going to determine what constitutes acquitted conduct by thinking about what the parties reasonably put in dispute at trial. And it seems to me that the weight of the drugs probably wasn't reasonably put in dispute, right? And so the judge could then consider that in sentencing a defendant with one proviso, right? It can't think of that weight as an indicator of an intent to distribute. And if there's an indication on the record that the court is thinking about it that way, then there's been a Beck violation.
So if the court says, in my experience as a judge, hearing these cases, that's more than a personal use, that's an indication of delivery. That's the Beck violation.
Yes, that's one such example of a Beck violation. I agree, Justice Thomas. The last thing I'll say is that in Beck, the court came to its conclusion that acquitted conduct is not permissible under due process for a couple of reasons. And it cited United States Supreme Court Justice Brett Kavanaugh's thinking about this. And Justice Kavanaugh said, look, acquitted conduct shouldn't be used at sentencing for two reasons, for fairness and for the appearance of fairness. And it does not comport with the appearance of fairness if a trial judge goes on and on about an individual's acquitted conduct, their intent to distribute in this case, and then in one fell swoop tries to take it back. A neutral third party in the courtroom is going to have real legitimate questions about whether or not the trial court is telling the truth. And they're going to appear like they have continued to take that acquitted conduct into consideration in violation of Beck's holding, which is that an individual is presumed innocent of the conduct of which they've been acquitted. So unless this court has any other questions, I'll save my remaining time for rebuttal.
Thank you.
Good morning. I'm Joellen Haas. I'm with the Ottawa County Prosecutor's Office on behalf of the people. You've asked us to brief two questions. The first one was whether or not the defendant was acquitted of the PWED charge in this case. The people's position was and continues to be no. And if you look at the jury verdict form, it is a simple form with 3 different boxes on there: not guilty, guilty of possession with intent to deliver meth, and then the lesser included of possession of controlled substance. The jury in this case was silent. They didn't make any specific determination as it relates to the PWID count. Moving on to your second question, assuming that the jury did acquit the defendant of PWID, the question is did the trial court judge violate Beck in the words that she said when she sentenced the defendant? I would say, the people would say no. And why? For the trial court to have violated Beck, it would have needed to make a specific finding at sentencing that the defendant engaged in the conduct for which he was acquitted, here, the PWID, the intent to deliver, and she didn't make any such finding. So what did this trial court do in comparison to what happened in the Beck case? And as of course you are all very aware, in Beck, the trial court found at sentencing by preponderance of the evidence that the defendant killed the victim. That's the specifically acquitted conduct because the jury acquitted the defendant of murder. And then the trial court used that conduct to aggravate the defendant's sentence on the felon in possession charge. What do we have here? We have a trial court that didn't make any sort of findings along those lines at all. Did she make a statement about intent to deliver? Yes, she did. But that was not in relation to a finding that the defendant intended to deliver.
Counsel, good morning. I just have a question. What are we supposed to make of the fact the judge went on at length saying things like, well, you know, basically talking about the crime that he wasn't convicted of and going through all the elements of it and talking about the fact that, well, you had a lot of money on you and, you know, that's usually symptomatic of being a person that is going to be dealing. How do we, I mean, it seemed like there was a lot of discussion of the crime that he wasn't committed, you know, that he wasn't sentenced for. It seemed like there was a great deal of discussion on behalf of the judge as it pertains to that. How are we supposed to relate to that? Like, what are we supposed to do with that situation?
Okay, so thank you. In this circumstance, you have possession with intent to deliver, and the lesser included is the possession of meth.
Right.
By virtue of being charged that way, the lesser is subsumed into the greater, so the elements are all going to be the same, but for the intent piece of it. The defense theory in this case was that the drugs belonged to somebody else. This wasn't a case of, and I think I'll get to your question, this wasn't a case where the police searched the defendant and found a bag of meth in his front jeans pocket, and so then he possessed that methamphetamine. In this case, the drugs were found in a safe in defendant's car, and those other items that Judge made reference to, the ledger board, the whiteboard specifically, was in the defendant's bedroom. So it kind of pulls in the baggies, the scales, and all that other stuff that she talked about in sentencing, because all of those items not only went to the PWID charge and those elements, it also went to the possession charge for which the defendant was convicted. So it was perfectly proper for her to have listed out in a summary fashion all of those things that happened in the trial as it related to the possession count that the defendant was charged with and convicted of, excuse me. This was a circumstantial case. The prosecutor was put to the task. She couldn't just check off possession pretty easily because the dope was in his pocket. She had to take all of those other pieces of evidence that circumstantially tied this defendant to the possession of the dope, which ultimately he was convicted of.
But she didn't articulate it that way, right? She didn't say that based on all of these other things, this is why I find, like, why you've been convicted of possession. She says, I find all of these other circumstantial things to be consistent with an intent to deliver. Isn't that problematic of, I get that perhaps she could have, right? Perhaps those other things, it could have been articulated, but we're left with what she's contended and said was the basis for her sentence.
Well, it was all of that in addition to, and I will drop down, she looked at the PRVs, she looked at the OVs, and they're in the PSI. All of that stuff is certainly relevant to that as well. And as memory serves, defendant had at least 7 prior misdemeanors that she knew about and was considering, and then the 5 felonies, and a couple of them were violent ones, armed robberies. She had considered, obviously, the defendant was on parole, and he'd been charged as a HOA 4. So there was a lot of stuff that the judge properly could consider as it relates to ultimately the sentence in this case. And so to get to your point, I've never been a judge. What is the judge to do when dealing with a sentence? Consider the things that are proper to consider, and she did. When the trial court's being reviewed by the reviewing court, what are they to look at? Well, how do we know what she meant when she said intent to deliver? She said those words. What did she mean? As you said, she didn't delineate, I find or I did this. So what do you look to? You look to her words. You can look to the record in the transcript. What did she actually say? And I would submit that there was more said by the trial court judge as it relates to why she sentenced the way she did, and I can certainly get to that. But so you're going to look to her words, what's in the record, and then what was the sentence? In Beck, it wasn't only was the defendant specifically acquitted, that's in there, but then is the sentence aggravated on the bases of the trial court using that acquitted conduct in an effort to increase or aggravate the sentence?
So what more would have been needed here for the judge to have inappropriately relied on it?
What more would have been needed to be
I mean,
here?
obviously, is it, as long as she hadn't used the qualifying words, I'm not relying on it?
Right, okay, so to be clear about your question is, what more would she have had to say
Right.
for me to say, well, that's a Beck violation?
Yeah.
I find, by a preponderance of the evidence, that you are a drug dealer, and not a user, and that all of this conduct went to that.
So she'd have to
I'm kind of making that up on the fly.
judge would
but-
have to specifically state that?
I'm sorry?
She would have to, you're saying that she'd have to actually state that, I find that you were there for distribution. Like she'd have to actually say specifically.
Right.
I find that this is, all these items were used for distribution.
Right. I think that the difficulty with the way the question is phrased is because each situation is going to be different for the trial court judge when they're trying to impose a sentence in a case. So what words do they actually say? Judges say a lot of
But counsel,
things.
I guess the concern would be, so is the only thing a judge has to do at that situation is simply say, but I'm only sentencing you for this specific offense, and then can go on about the other offense. And as long as they say that,
No.
well, I'm only sentencing you for this specific offense, that would be sufficient enough for it not to be a Beck violation?
No, I'm not exactly saying it that way, because I know there's been a fairly recent case that talks about essentially just even uttering anything that indicates reliance on acquitted conduct is off limits for the sentencing judge to consider. But you can also look to, you as a reviewing court and an error-correcting court and giving guidance to your lower judiciary in these circumstances, I understand why you're asking the question. What is a trial court to do in this circumstance? And I'm saying you do look at the words as an indicator of what was the court thinking, but you can also look to the sentence that was imposed too, because that's the other part of Beck. Was there aggravation here? And I would say in this particular case, for all the reasons that I had already just stated, and she didn't aggravate this sentence. Yes, she went to the top of the minimum guideline range at 46 months, but she could have gone outside of that. She didn't do that. She stayed within the guidelines because of all the reasons that she did state on the record. She did talk about his history. She talked about good parts of Mr. Wells' history as well. So it wasn't just very succinctly, not considering the acquitted conduct, but I'm going to talk about it a lot, and that was all she did. I don't think that that is a representation of actually what happened here, and she was asked about it after the Ginther hearing, and she had generated a brief in response to that as well on this issue. And she responded, no, these are all the things that I relied on. I convicted you of possession of methamphetamine. So now she's said it in the sentencing hearing, and she said it in her written opinion. And now this court is faced with, well, what do you do about this now? What is the remedy here? Is it to send it back down to her to say it a third time? I don't know. That doesn't seem like that would make much sense to me. This court had said in the Beck opinion, as we must, we take the trial court, what they say, we take them at their word. I think that's important here. The trial courts are navigating and trying to work through all of this, PSIs, victim statements, all this other stuff that they have to take into consideration in an effort to impose a proper sentence that's appropriate for this defendant for this offense. Beck isn't a new case. I mean, I think it's about 6 years old now. So I'm going to presuppose, I think it was 2019, presuppose that Judge Biedema was aware of Beck. This case actually was in 2021, so it wasn't 2025, but still, Beck had already been out. About what those things that this court said to the trial court, you know, if that person, and I'm pointing to the defendant over here, if that person was acquitted by the jury, Judge Biedema, you cannot use that conduct that he was acquitted on in an effort to aggravate or increase the sentence in this matter.
Counsel, how is this case different than Brown, which is one of the Court of Appeals cases I think you were talking about, where the judge, you know, mentioned acquitted conduct and then, you know, tried to sort of say, but I'm not relying on it. Why is this case different than Brown?
Well, I think in that case, that was the one where the judge did go through this analysis of the categorical approach versus that rational jury approach, and sort of went that direction. I think that this case is different in that all of the same facts that applied to the greater also applied to the lesser. And so that conduct, I mean, the conduct, the facts, however you want to call it, it's the same thing as far as I understand it to be. How do you parse that out? And particularly in this case, and that's why this case is different. That's why this case, I understand that the court wanted to hear this case for whatever reasons it chose to do so, but because of the facts in this case, this is the people's position that this, if the court's intent is to expand or do something else with Beck, this isn't the case for it. Because factually, although it is a necessarily included lesser offense case, the verdict form looks fairly easy. It's a one count, although the possession of meth was added at trial. It wasn't a multiple count thing where you would have to consider all the variations on a verdict form. And there wasn't a specific acquittal here either. So in addition to that, the facts of this case aren't just simply you can parse out and you can pull out the intent piece of it. So for example, if you change the facts of the Wells case and say the dope was in his pocket, and that's where the police found it, and the jury came back and said, check box on possession of meth, I think I would be hard-pressed to make an argument that it would be hard for the court to parse out these things that she said. Why would baggies and scales and all of that stuff matter? If the dope was in his pocket, there's possession. That's what the jury found him guilty of. All that other stuff goes to intent. But you have to change the facts of this case to make that work. And that's why this isn't the case for it. Again, as I said, the prosecutor had to tie all of those other things together circumstantially and say, and oh, by the way, that's why, jury, you should find him not only guilty of P-Wood, also a possession of meth. So I think that that's kind of one of the things that I would say, I hope I answered the question, is a distinction there.
You did. So your time
Thank you.
has expired. Thank you for your argument. Mr. Burton, you have a little over 6 minutes.
Yes, Your Honor. I have a couple points that I'd like to make in rebuttal. The first concerns the nature of the evidence that was introduced at trial. So the prosecutor just talked a lot about this idea that the baggies and the scales and things like that were circumstantial evidence of possession. But that's actually not the case with regard to Mr. Wells. So his trial attorney made two separate arguments. The first was that he's not a drug dealer because these baggies and scales and things like that are innocuous. They're actually for his cheesecake business, which everyone testified that he had, that he was a baker. The evidence, or the argument with regard to possession was that he didn't know what was inside the safe. So his trial attorney spent a lot of time trying to suss out what Mr. Wells knew about the safe, when the safe came into his possession, things like that, to determine whether or not he actually possessed the methamphetamine. Nobody argued that, or at least defense counsel didn't argue that those baggies and things weren't circumstantial evidence of possession. They were not circumstantial evidence of his intent to distribute. And more specifically, even if you do think that those things are evidence of his intent to or evidence of simple possession, the trial court did say you have an intent to distribute, and that disposes of the matter. The second thing I want to say is that the threshold for a Beck violation is low. In Beck, this court said that it just has to, a Beck violation occurs when a judge sentenced an individual more severely, even in part, on the basis of acquitted conduct. So there doesn't need to be a departure sentence. And I believe that the prosecutor, when she was talking about a recent case, she was referring to Skipper Gosh. And that's a case where the trial court did briefly reference acquitted conduct, much less so than Judge Miedema did here, and then went on much longer, 6 pages of trial transcript talking about permissible sentencing considerations. And even then, the Court of Appeals found that there was a Beck violation. In this case, Judge Miedema talked about permissible sentencing considerations for maybe a paragraph. The last, I want to make 2 more points. The first is that Judge Miedema's comments at the Ginther hearing and in her opinion after the fact are not her disclaiming a Beck violation. She seems to be under the impression, in that opinion, that just because she did not impose a departure sentence on the basis of acquitted conduct, that she did not violate Beck. And that's what she says in the opinion. And that's not enough, as evidenced by the body of case law that the Court of Appeals has produced since Beck. And the last thing I'll say is that the remedy is resentencing. This was a due process violation. Mr. Wells's sentence was not imposed under the presumption of innocence, and so the remedy is resentencing. So thank you.
Thank you. The case will be submitted.